G'day, I'm Stephen Page from Page Proven Family and Fertility Lawyers, and welcome to the Australian Family and Fertility Law Podcast. I've been doing this game a long time, and it is still extraordinary that I've appeared in some groundbreaking cases that get reported, and I talked about that in a recent video called Ma and Pa. But this case isn't about Ma and Pa. This case is about a couple of gay guys, a couple, who I had the honour of representing in the ACT Supreme Court. And the case doesn't have a name as good as Ma and Pa. I think it's really an application under a parentage application under the Parentage Act 2024. I'll start it again. A parentage application under the Parentage Act 2004 ACT. Pretty forgettable name. But what was the case about that was significant? It's first reported case following changes to the ACT's Parentage Act, a 2004 legislation that happened in 2024. Prior to 2024, there were real problems with the ACT Parentage Act. It was the first surrogacy legislation allowing surrogacy in Australia, and by 2024 it got a bit creaky. And therefore, whilst it had been pioneering at the beginning, by 2024 it was really outdated and it needed updating. And some changes that I certainly made submissions about and the ACT Legislative Assembly enacted included that traditional surrogacy could now happen, because previously if you had the surrogate as the genetic mother, you could never get a parentage order in the ACT, and you weren't stuck to having to do the IVF in the ACT, you could go anywhere. And again, that change has come through. And then there were some transitional provisions, so that if you'd had a couple from the ACT who had, for example, undertaken traditional surrogacy and or they had done IVF somewhere else, they could get a parentage order now. And that's where my clients were at. I was acting for a gay couple who lived in the ACT, and they had a traditional surrogate who didn't live in the ACT, and IVF was not done in the ACT, and about the time that the bill that became the 2024 Act came about, the child was born. And so the surrogacy arrangement was drafted as a New South Wales arrangement. They were going to move to New South Wales and therefore get within New South Wales jurisdiction, but that never had to happen. Instead, my client said, well, we want to do it here. And they waited. And they waited until the legislation was enacted, and they waited until their material was ready, and then we filed. And I'm delighted to say that Acting Justice Muller of the ACT Supreme Court was prepared to make the orders. That even though they hadn't been compliant with ACT law at the time, they fit under the transitional provisions, and as a result, they were recognised by the ACT Supreme Court, and therefore for all purposes under Australian law, as the parents. And importantly, from their son's point of view, his parentage is recognised Australia-wide. That's a good thing. Thank you for watching and listening to the Australian Family and Fertility Law Podcast. I'm Stephen Page from Page Proven Family and Fertility Lawyers.